But we haven't worked on it.
We have section 7, and then we have to finish in relatively brief compass because we have a speaker from the governor's staff coming to speak to us in the courtroom today at 5. So we're going to have to move a little faster than we would otherwise. But what we're here for to start to think about is insurance practice issues, including what's known as Statute 176D, General Law Chapter 93A, and Rule 56. So let's start with Rule 56, which is the rule of civil procedure with respect to summary judgment, as we've talked about from time to time, and we'll look at it again when we see it in some cases later on. Summary judgment is a frequently used civil motion. What it's trying to decide, in essence, is whether the case is jury worthy. But what it's really testing are the pleadings and everything else that's been gathered up to that point to see if there are material facts and issue that rise to a triable level, and whether the moving party is entitled to judgment as a matter of law. The modern procedure is not just found within Rule 56, but for instance, if we're in Superior Court in Massachusetts, there's a separate rule on it, and as well, if we're in federal court, there's what we call a local rule on it as well that talks about the procedure one must engage in if they're going to file a motion for summary judgment. And it's quite extensive and quite detailed, and you're going to have to, if you do intend to move for summary judgment, really pull all the record references together, file what we call an uncontested statement of facts, and then file what we say are contested statements of facts, along with your memoranda, along with your affidavits, and then the court will look at that extensive material to determine whether the case can go forward. But in federal court and superior court, to either move for summary judgment or oppose it, and in a case that even is marginally involved, can be a fairly expensive proposition. Obviously, it's still cheaper than trying that case, but you have to be prepared to roll up your sleeves and really do a lot of work in a lot of these cases. And so it's a little more involved than what you see in the rule of civil procedure, because by local rules in both Superior Court and Federal Court, the process is much more detailed. I've got one upstairs that's kind of involved, and I'll bring it down just so you can show the mass of materials and sort of look and see, understand the scope of what we're talking about. But we also have a couple of other very important issues to talk about with respect to 176D and 93A. A lot of what we do ultimately in practice, one way or the other, involves some relationship to an insurance carrier. Whether it's we're the plaintiff and we're seeking to recover at some point, and whether it's an auto accident where we hope there's insurance policies available, or you've got some type of homeowner dispute which hopefully someone might have enough coverage that would pay for it. I had someone I was talking to who was bitten by a dog, and you hope that the insurance carrier, that the dog is owned by someone who has insurance of some sort, hopefully a homeowner's policy that might cover that type of injury, because those can be quite extensive, and you've got to think about that. I'm being sued for an accident one of my children got in, and obviously that is involved with the insurance policy on the vehicle. And frankly, we've had quite a tug of war about what they should do. They believe there's absolutely no liability, so they shouldn't have to make an offer. And I would agree with them that it is a horrible case that the plaintiff is advancing, and certainly not meritorious at all. Nonetheless, I would like them to settle the case because I don't want any exposure whatsoever. I try cases, as you know. Any case that gets tried, there's a risk that you could fail, even with the greatest facts in the world. So we've had a tug of war over the last year just about make them an offer. Because the policy, here's the point with insurance carriers, 176D. They have an obligation, we're going to see it within the statutes. They have an obligation to defend an action that falls under the policy, right? So they have to provide you with representation. They also have an obligation, as we're going to see, that once liability becomes reasonably clear, to make an offer on your part to settle that claim so that you are not exposed. Here's where the rubber hits the road, though. They don't want to pay at all, right? The insurance company, for the most part, they get to keep their money as long as possible and hope that someone else will walk away. And so what they would like to do generally are two things. They'd like to handle the case with the attorneys on the cheapest part they can. And there's a couple cases I'm going to be talking to the bar exam students next week, and there's a couple cases that came out this year that are important in that regard. One of them would be, you know, if the attorney charges $200 an hour, the insurance company is going to have to pay $200 an hour to defend it, not what they set as an artificially low rate simply to do it. So they have to get you counsel to assist you, and then they have to defend when liability becomes reasonably clear. But the fact is, if you have a $500,000 policy and the defendant will take $50,000, well, then give them the money, right? Who cares? It's not my money. It's not your money. It's the insurance company's money. Well, the insurance company doesn't want to do that, because what they like to do is keep all that money, and they'll take the risk of trying the case thinking that they'll do better than that. Well, that's great, unless they do worse than that. And as long as they don't do worse than that up to $500,000, you're okay. But if it goes beyond $500,000, then that means they're only on the hook for the first $500,000 and you're on the hook for the rest. So there's a tension between their fiduciary obligations to you as their insured and the what you would like to have happen, because you would like to not be exposed to the risk and the concern of it at all and the rest of it. And so oftentimes, while they will appoint counsel to represent you in the case, whatever the litigation is, whether it's a car dispute, a home dispute, or whatever, the fact is that you still may need your own representation to force them to do the right thing under the terms of the policy, to settle, to push hard for a resolution, to give you an attorney. And I think what I'm seeing as more the trend is more of those attorneys that they're appointing are captured in-house attorneys. So they're not even paying the $200 or $300 an hour outside, which means that there's a greater encouragement for them to settle if there is a real cost to the litigation for them. And I'll be honest with you, in my case, they have not come north of $3,000. And we had a huge fight over this because I don't think that's a reasonable offer under any circumstances. I would never. As I said to them, until you offer them more than that the risk to try that at least justifies their involvement in the case, they're never just going to walk away for $3. Maybe 10 would do it. 10, at least by the time you split it out, take your fee, you got a few $1,000 in your pocket. But if you don't offer me at least that, then the fact is you're offering nuisance value, and there's just no way. That's not a reasonable offer under the circumstances. But they figure they're going to win a trial, so they don't care, and they figure the cost is sufficiently small to take it to trial because they're using in-house counsel, that it's not a problem. It's a problem for your client, and that's the tension we're going to look at in a couple of these cases. What 176D does is force them to be reasonable. It's your leverage with the insurance carrier. It says that not only do you have to be reasonable in how you deal with me, you have to be reasonable in how you treat settlement offers, and you have to make reasonable assessments that are in my best interest, not necessarily yours. You know, because frankly, so take the case that I'm explaining to you. It's in my interest up to $500,000 that they write that check. The case is probably worth $0, right? If it was my own money, well, I don't know. I'd still have to think, because if the cost is relatively low enough, get rid of it. Why take a $500,000 risk if it's $5,000 to make it go away, or $10,000, whatever it is? But they do their numbers and all the rest of it, and they come to a different conclusion. That's fine. Then you share the risk. You accept the responsibility if the judgment is in excess of the policy. And that's what we've been fighting about, and only recently resolved that issue. Go ahead.
If they fail to make a reasonable offer, as required by the statute?
Yes.
Do you have a claim against them?
Yes.
If it goes to trial, you lose and it ends up costing you?
Absolutely, and that's
Your
what.
damages are whatever you end up having to pay.
Yeah, you know what, actually, and there's a case that just came out, and I've got it, I'm going to talk to the students who are taking the bar next week. It's not just the difference in the value of the money. The Supreme Court said last year, and I'll get you guys this case so you can look at it, the difference actually is if you ended up having to sue under those circumstances where they have not made the reasonable offer of settlement, the case says your damages actually are double the amount of the judgment. And what that means is there's a real incentive to them to try and push this issue and to try and get a satisfactory resolution to it. And I'll look at the date of the case because maybe that helped to give them some incentive in addition to my concerns. But that the measure of damages should, as you said, be the difference. That's not really the way it's calculated. It would be a bonus, except of course I would have to sue in order to do that.
And they're banking on the fact that there's no way it's going to exceed 500,000 anyway.
Correct.
Right? So,
Well, but that's the point. If that's your argument to me, there's no way it can exceed the policy limits. No way. Well, then you shoulder that burden. If you're going to play with my house, then you say, okay, we'll cap it. Because I've proposed various ways to resolve it over the course of time, none of which involve a lot of money for them. But to me, if I were the plaintiff's lawyer, and I really do think this case it never should have been brought in the first place, honest to God. It's one of these lawyers that's on the billboards and stuff like that. But nonetheless, it's there and it's approaching trial. Well, you've got to be reasonable about the risk that we're exposed to under the circumstances. But
And under their plan, they may blow yours, but they got 6 others that they make up for it on, and you still get.
That's exact. See, and that you understand that. See, that's the problem. They're playing the statistical analysis and the odds. So if they take them all to trial, ultimately the statistics bear out that they'll be just fine. That doesn't leave the policy holder, the insured, with any comfort level, and shouldn't leave them with any comfort level, because you could be the 1 in 6, and they're going to walk away from any, or they think they're going to walk away from any excess judgment. And that's what I've been documenting over the last year. Is you're not going to walk away because you haven't honored the terms of the agreement and your obligations to me. And that's exactly right. Is they're playing the statistics. Well, you play enough statistics, that's fine if you're playing with for a long enough period of time. In any one case, you're leaving policyholders exposed. So let's take a look, because I think Timpson is a great case, and Timpson really brings us into a little part of 170-60 that you need to think about. It also brings us into, for you to start to think about, and this happens a lot in practice, tested on the exam as well, is when is an agent responsible for, when is a parent responsible for the acts of their agent, right? Respondeat superior and the like. And when is he really acting on behalf of the company and not just for himself? One thing to remember about this, we're going to look at Timpson. One thing to remember about this is and I think sometimes this is overlooked, when we're trying to hold the parent liable, and that's in part what's going on here, that's what at least she tried to do. That doesn't mean the agent, the individual, isn't responsible for their own torts, right? The fact is this gives us another pocket to look to. So if you are Ms. Olson, you're suing the New England Patriots and the individuals who were present in that locker room who committed these acts, and you're saying that these highly offensive acts, not only should they pay for, but they should pay their employer or their principal should pay as well. So you read the facts of the case, and it's a summary judgment case on behalf of the insurer. She's in the locker room. He wants to say that he's engaged in the scope of his duties at the time he's committing these acts. And let me take that from that standpoint. In some ways, he is, isn't he? Not at all? Huh?
What he says he's team unity, he was a leader.
Well, it is a little bit of team unity, no? So the test talks about the Wang test, right? And that would mean that someone is acting in the scope of their employment at the time they're committed. Does no one think, arguably, he's got a basis to say that what I was doing was in fact of the type I was hired to do? I mean, he is required to interact with the press, correct?
But not in the manner in which he interacted.
Well, what do you mean by not in the manner in which he ultimately
Well,
did?
they talked about that in the case, that he's supposed to exude a positive image to the press and make it easy for the press to have access to them, not to berate the press, which is what he did to this woman. I mean, that was
Well,
his
he
defense.
acted abhorrently.
Right.
But football players are prone to do that, aren't they? No. You're in a locker room with men who play a dangerous, violent sport. You expect them to act 100% appropriately, and they're naked, right? They are naked. No, they are, aren't they? You're going to their locker room where they change, where they shower, where they do whatever, and by the way, and you're female. You must expect some type of raunchy, inappropriate behavior. That's not expected.
I think it should be. It should have been.
You don't think it should be?
I think it,
Yeah, it should have been.
You think you should expect it?
I think you should, I think that she put herself in that position, I don't think she should have done that.
What do you think of that?
Well, I agree. I said it should. I think
She should have what?
She should expect that kind of behavior going into a locker room of football players.
And go ahead.
Okay, but that's not what we signed the contract for. It means the contract does not have a provision that allows them to act wrongfully and disrespectfully. I think the line has to be drawn somewhere, and I don't think that she has not done that.
Well, the contract requires them to perform football and to interact with the press. Go ahead.
I would say that as their job, it's not their job to be inappropriate. It is their job. They could stand there naked and still be appropriate when speaking to. But the fact that they were being so rude and inappropriate to her is unprofessional. And yeah, she was in there, but she was doing her job.
Ray and then John.
But how is this different from a reporter walking into a war zone? How is it different? They know the circumstances they're contributing themselves into. They know that they're going into a men's locker room with football players, and this is what's going to happen. It's no different than a reporter, going into Baghdad with a bulletproof vest on their chest. They know the situation they're getting involved in.
Well, is it different, Geneva?
I'm going to go with no, because I think that a lot of football players wouldn't do that. And I think that a lot of coaches wouldn't be okay with their players doing that. So you can't say that you expect every single one of them to act like that. And same with when you go into a war zone, you're not expecting other people to do things to you on your own side, you know what I mean? They're co-workers, basically, because you have someone interviewing an interviewee, and they should be working together for, by their contract, they have to.
Stefan and John.
I was just going to say, when it comes to the interviews that they conduct with the news media after a game, I think it's the football players' job to use their efforts in the media to advance the Patriots' interests and to talk about the game that they just played and, talk about their fans and everything else, and certainly not to sexually harass the reporter and act inappropriately to national television or whoever's watching them.
But go ahead, John.
Yeah, I think it's big business. I mean, his arguments really fail when you look at there was discrimination going on, and where the line really should have been drawn was this wasn't her taking on extra risk. The line should have been drawn at either, you have them both, male and female, in the locker room, or you have nobody in the locker room. I mean, I agree it's kind of an absurd situation, but I think if you flip the situation and say, well, how come men aren't interviewing women while they're changing in the locker room, it's because it's not important in the same economic way.
The Wang test says here, 1, the conduct is the kind he's employed to perform. 2, it occurs substantially within authorized time and space limits. And 3, it is motivated, at least in part, by a purpose to serve the employer. Are there any of those tests that you would see him satisfying?
I think that test, I
the second and the third requirement could arguably be satisfied here. But the first one, definitely not. I just think
Go ahead.
if she went into the locker room and say her claim was just that they were exposing themselves to her, I think that's a weak argument because she should expect that much going in there. But the fact that they then harassed her, I think that's where the line is drawn. So I think that she does have definitely a fair argument here. It wouldn't be fair for her to go in there and then say they were standing in front of me naked. Well, you expected that when you should.
But it's the sort of the sexual assault
Right.
aspect of it that it falls outside the bounds of what anyone should expect.
Yes.
Look, do you guys agree with her? It occurs substantially within authorized time and space limits.
Yeah.
Right? So number 2 is satisfied. 3, and now what do you think about 3? Is there any? It is motivated at least in part by a purpose to serve the employer. I mean, as twisted as it might have been,
I don't think the act itself was motivated to serve the employer.
At least in
but-
part?
But the interview, the fact that he was having an interview with her is within the scope of his employment. So I don't think that that test of whether it's a total abandonment of his duties is a hard one to make. I think the fact that he's being interviewed by a reporter is within the scope of his duties.
Well, he wasn't being
Yeah.
Well, that's
interviewed.
one,
I
though.
think-
He wasn't being interviewed. He was behind
was
the.
Well,
interfering with
yeah,
another
the other
interview.
guy.
well, but another guy was, and he wanted to show a little team unity here. No, right, that's what he says, right? Guys being guys, and so he wants to.
I'm sure, yeah.
No, but so wait a minute though. So Freddie, I hear you making the argument that 1 may be satisfied as well.
I think
She said 2, and no one seemed to object to 2. I want to know what are you guys telling me about 3? It is motivated, at least in part, by a purpose to serve the employer. What about that? Even if it's twisted and messed up, can we say, well, that's not motivated? Are you saying his motivation wasn't even in part? Awkward, but in part? Well, because then I'm going to tell, if you're going to give me 3, I'm wondering about 1. The conduct is the kind he is employed to perform. I mean, I imagine many of you could make an argument that he's employed to perform, to interact with the press as part of his duties. If I didn't have to do this, I wouldn't do it in the locker room. I would choose somewhere else. But you guys make me do this.
I think it's 3 and not 1 because in 3 there's that part of at least in part for the purpose of serve the employer. What this started out as is them like getting hyped up or whatever because of the game. But so I think in part it was because this was all just part of their like what they probably always do when they're excited about a game. And she happened to walk in there, and although all of it was not part of the harassment was not part of it, that at least in part it was because it was just their regular conduct from what it seems like that she happened to walk in on.
By the way, you guys realize from the flip side of this, I know the case is here from Timpson's standpoint, but you realize if he's not acting within the scope of his duties, the Patriots don't owe her a dime, right? And the same thing about the woman then who's sexually harassed by her boss. If he's acting outside the scope of her duties, the employer doesn't owe a dime either. So that's really in part what we're doing here as well. We're saying, no, he's acting on his own. The Patriots aren't responsible for this at all if you don't think 1, 2, and 3 are satisfied. I want to know how you compare this with the Grimsley case that's cited in the same thing. You saw that? Because it says, relying on Manning versus Grimsley, First Circuit 981, which is us. Professional baseball pitcher who intentionally threw a baseball toward hecklers and injured a spectator. So, baseball pitcher can throw a baseball at 90 miles an hour. Was found to have acted within the scope of his employment because heckler was interfering with the ability to perform, and thus quieting the heckler would likely result in better performance by himself and the team. That's what it says, right? Don't look at me like I'm making it up. I'm making so Grimsley's within the scope of his employment, but misguided Michael Timpson is way outside. Yeah, it's that simple. Hold on, let me get Scott. Now, come on.
Not necessarily. I mean, the reason that this whole thing happened in the first place is because the women reporters wanted access to the locker room. Guys would walk around the locker room naked all the time, and they didn't want to have to change that. And we were going through this, typical transition of society where you've got to go through this kind of a conflict to make that change, in this case, to allow women reporters to wander around the locker rooms, like the men reporters were doing. And these guys had the attitude that, well, now we got to watch out when we come out of the shower, who's out there. We don't want that stuff. We don't want them in here. And so it's like, okay, you want to come in? We'll show you a wank test, and off it went. And it might have been misguided, it might have been a little crazy, but well, you started it.
You're being recorded. That's what it's called. That's what it's called.
But seriously, I think this was their misguided way of saying, if they want to come in the locker room, this is what it's going to be like.
So you think he falls within the rule of
He thinks he did.
No,
well,
you-
yeah, I think it makes a point.
So.
It makes a point.
He's close enough to Grimsley that he's acting in the scope of his employment.
Right, in this case.
No, if anything, he's interfering with her job. Like the heckler was interfering with his ability to perform. She's not interfering in his job at all by just being there. So that doesn't end.
Well, my guess is, though, that the argument is she is interfering with us. We want to do work here. We shouldn't have women running around our locker room.
So you get to sexually harass them.
No, I think the sexual harassment becomes a problem, because that's what the court specifically says, that, it says, second, the conduct in which he allegedly did participate, sexual harassment, was not the kind of conduct that he ever would be legally employed to perform.
Yeah.
Right?
It's not a question of whether he did committed a tort or a wrong. It's a question of who's responsible for it. She wants to be able to sue the Patriots, not him.
And what he's looking now to do, just so we're clear on the case, because this is why it's an insurance issue as well, he's looking to recover the legal fees he spent in defending this suit because they refused to find that it was covered under the policy, that he was in fact potentially acting within the scope of his policy. Sometimes, by the way, they will defend those cases under what they call a reservation of rights. We'll defend it, but we're not agreeing to anything yet as to whether it's covered or whether the defense costs are covered until such time as we have more facts of the case to determine whether it's going to fall within the policy. But here they said from the outset, you get your own attorney. What was it, 76 grand he spent prior to the case being settled. And so he's saying that that like Manning, he's promoting better team performance by laughing and shouting encouraging words to his male teammates, all of whom were allegedly sexually harassing the female reporter. Timpson was promoting team unity. What are you saying back there? Go ahead, Karen, go ahead.
What they say in the case, and I think this is the essence of it, he made a legally enforceable contract to cooperate with the media. Cooperation, and he was not cooperating with the media. So that's, and he wasn't doing, not only wasn't he cooperating, but he wasn't cooperating. You said he was in the locker room. He wasn't on the field playing the game as the baseball player was. So he wasn't participating in the game. This wasn't.
But don't you think?
But the locker room stuff is all part of.
Isn't the motivating what?
Do they have to go to the locker room and shower? Can't they just put on their clothes and leave? Is that part of their? I don't think that's the case.
No.
I don't think that's a requirement. I think after a game, if they have to leave, they could just leave.
No, but it's an implied part of like them getting together before the game in the locker room and what they do to prep for it, and afterwards it's part of that team cohesiveness thing. So I just think
But it's
that
irrelevant
because
he wasn't cooperating with the media, and that's what his contract said he had to
That's a
do.
different issue, though.
But it fails on that right there.
So you don't have the interviews.
But isn't the motivation his personal motivation, even if it's misguided?
Well, I think his motivation does matter, and I think the court saw through his argument. That was brought up after. That's probably an attorney telling him, this is what you should say, because at the time when someone sexually harasses someone, their motivation is not team unity. So they never would have done that to a guy who was in the locker room, and that's why I think the court saw through it, because then if you could say that equally, no matter who the person was that was interviewing, you behave the same way every time, then maybe you can say we do it because of team unity. But you wouldn't do that to a man. So you only did that because you wanted to sexually harass and embarrass a woman. So therefore you're not motivated by
But suppose they did just want to harass and sexually humiliate a woman. Couldn't that be motivated to bring about team unity?
No, because it has nothing to do with the team being.
Sure, it is. All of us guys being guys, joking, laughing, ha ha ha.
that's a big assumption that all guys want to
Yeah.
humiliate women.
Well, no, but maybe they just
Don't you
didn't
think the
want-
guys present doing this, she said that's what she thinks.
Well, she would have sued all of them.
I think she did.
I think
The
she
whole
only
team?
sued 3 of them.
No, it was Zeke
She
Moab,
did,
Michael Timpson, and someone else, in my recollection.
But that's not the whole team.
Yeah, so
No, it's not the whole team, it's the guys present at the time.
Right. But no, there were a lot of people present, and I think she just sued the 3. that
So
were-
his personal motivation does or doesn't matter, even if
I
he ends
think-
up being,
I think his personal motivation would have mattered for the one that we were talking about whether it's motivated at least in part by a purpose to serve the employer. If it had been, if someone could have believed the fact that in general you could be motivated to sexually harass someone because everyone does that to form team unity, then I think that people may have seen it differently. But in this case, that never happens, and it wouldn't have happened with a male.
so if your boss sexually harasses you, at least under the terms of the Wang test, that's never going to be the responsibility of the employer if just those facts exist.
If you, oh, sorry, go ahead.
Right?
I was gonna say, if you can prove that your boss encourages that, and that, or like the boss
The company.
encourages that, the company.
No, your immediate supervisor has sexually harassed you for a period of a year, grabbing you in the ass, doing whatever you want, who would you like it to be? Whatever you would like it to be. 5 minutes?
It's 5.
Huh? Okay, just a few more minutes. No, right? Is that never covered? Because it's not the kind you're employed to perform, correct? No one hires a supervisor to handle their employees in such a way, right? So, and it's authorized time and space if it happens on the job. And I guess we could make the same argument for 3 again. Well, it's motivated. I like to make the employees feel welcome, friendly. All right? I mean, same type of argument could be made, but you'll never satisfy one. So that means, at least according to this test, you might be able to tag the immediate supervisor, but you're not going to tag the employer. So you're not going to be able to really get the money, because
Well, but you may have an argument that the employer condoned it, that they knew.
well, that's
this-
different. That's a different
But
different
that's-
theory, right? Hostile environment, or
That's-
sort of blind to allowing him to do this after all this time and not taking any steps. But that we're moving away from the Wang test at that point of authority to responsibility to be responsible for the acts of your agent. He was saying there's other acts present, and if you think about this, when we're talking about this type of agency, then a lot of these activities that we think might happen in the workplace or elsewhere aren't likely to be falling within the conduct as the kind he is employed to perform, or is motivated, at least in part, by a purpose to serve his employer. And if an employee, as it goes on to say, acts from purely personal motives, that's not always easy to see. And I think this one is a nice one, because it is pretty. I mean, if this happened out in the street or outside in the locker room, the likelihood is some of these guys might be charged with criminal acts for what they've done here. And the fact is, it's an interesting argument, legal argument he advances. The problem comes in when we really start to apply the test. And I still have a problem with how you're distinguishing it from Grimsley. I can throw a baseball at the face of a heckler, and that's within the scope of my employment. But harassing a female reporter isn't.
I'm just assuming that in that situation, there was something that was disrupting the flow of the game. And this has nothing to do with the main part of sports, which is the
Can't you
game.
always make that argument, though, that, well, he's yelling stuff and it's bothering me? I mean, geez, you're a professional athlete. You should be used to that.
I agree with you.
So how's Grimsley covered? Go ahead.
I mean, I don't think in either case they were correct in what they did, but and all the same, I don't think that they are different, because in Grimsley, you know, if he wasn't in that environment, he wouldn't have thrown the ball at someone's face. Same with this guy. If he wasn't in that environment, he wouldn't be sexually harassing someone. You can also make, that argument, and that I think they are the same.
See, that's where the time and space, we're oftentimes going to have acts within the time and space, The problem is that's why we have to apply the other two parts of the test as well.
I was just going to say, maybe, I don't know if I'm far off in this, but could you liken it to spiking the ball? Because it meets all those factors, but you're still going to get fined for the excessive celebration.
Well, it's-
I don't.
Go ahead,
Yeah,
yeah,
it's
go
There's a
ahead.
case that I read recently, and the priest is also a psychologist. He ends up having consensual sex with a woman who's a member of the church and seeing him for psychological counseling. And the church gets held liable, even though, you know, one would think that that's outside the scope of his employment to have sex with this woman. This is similar. I mean, but they're held liable by respondeat superior. I mean, but.
Well, but
you
see,
know,
I don't, that's why I was trying to distinguish it for you. I don't think it's a straight respondeat superior, because you just saw, the WAG test is seriously, I mean, that's the real test. That's the test we tend to use for whether the parent is responsible for the acts of the agent. And so in the sexual harassment cases, and actually when you do start to look at this, you do have to look further. It's not just that it was committed by your supervisor, because as you can see, it's pretty hard to make that test fall against the parent. What you're going to have to show is that, you know, it's either the hostile environment, that they were aware of this and took no steps to correct it. There's got to be something more, and my guess is, at least in some of those cases, certainly with the priests, that they're aware of it, failed to take corrective steps, and that they allowed, in essence, the dangerous condition to exist.
And there was nothing in the fact pattern of this case that would indicate that the church was aware that this relationship was going on.
That was,
You know,
I
the
think,
lower court ruled that the church had no responsibility, but that was, on appeal, it was overturned. So my point is that because of the time and space required, you
Yep.
know, to me, it seems like the deep pockets, you know, the insurance company should cover
Well,
this.
but, and see, that's the thing we're looking for here, and that's the thing to start to think about. Okay, so I can get the immediate supervisor, but on a claim of any magnitude, so what am I looking at? I mean, they don't likely have an insurance policy of their own to cover it. They may have a house, but that may be subject to protection by homestead and mortgage and everything else. So I'm gonna have to try and push all of this, and maybe without recovery. That's why we look for the parent's responsibility, because they likely carry insurance coverage, they also have liquid assets. It's a lot easier to try and hit that deep pocket, and that's what we're looking for. We've got the governor's counsel here. Let's call it a night for tonight. See you on Thursday.